I call the Honourable David Parker.
Thank you, Mr Speaker. For a start, can I repeat the thanks that has been made by my colleague Charles Chauvel for the way in which the National Party conducted themselves at Select Committee. It was chaired by Chester Borrows. This is one of the most complex and difficult pieces of legislation that I've considered in any Select Committee since I've been in Parliament, and it's one in which the Select Committee took very seriously the proper balance between protection of civil liberties and the necessary powers to be afforded to state agencies to investigate criminal conduct. The need for an update of the law had been made clear by the Law Commission because there were various powers in New Zealand that were being exercised by the police in an unregulated form because the original legislation passed in yesteryear didn't cover some of the new technologies that have been developed since, and so it was clear that there was a need to update the Search and Surveillance Bill. I don't have time to go into the detail of the many changes that were made at Select Committee with the cooperation of the Minister and members of the Select Committee. Suffice it to say that other than issues that Charles Chauvel and I have been talking about today, we are satisfied that the bill represents an appropriate balance between powers that are needed by the state and civil liberties that we need to protect for our citizens to be free from unreasonable search and surveillance by state agencies. But we are left with some very serious issues. And I do want to put on record what I think has been a deliberately political and improper dealing with the concerns that have been raised by me on behalf of the Labour Party. While the bill was at Select Committee, it became abundantly clear that the issue of Serious Fraud Office powers needed to be addressed. Why? Because at the time when this was at Select Committee or thereabouts, the Serious Fraud Office, without a judicial warrant, exercised their powers against the National Business Review to seize or to claim a right to seize records relating to the National Business Review investigation of the South Canterbury finance failure. It became absolutely apparent that this was a problem that needed to be fixed. Now, it needed to be fixed by changes to the Serious Fraud Office powers to make sure that they can only exercise their powers if they go to a court and get a warrant. At the moment, they don't need to go to the court to get a warrant, and that is the fundamental problem that we have with the Serious Fraud Office powers. This issue came to light because when we were in Labour in the prior government considering these issues, at the time we were proposing a merger between the Serious Fraud Office and the Serious Organised Crime Unit of the Police, and so there was a discussion as to what powers should be carried forward from the Serious Fraud Office to the police. At the time, the Law Commission recommended to Cabinet that none of these powers for examination orders and production orders, which are an undermining of the right to silence, should be carried forward to this new unit. There was some public disquiet about those powers being taken away from the Serious Fraud Office at the time when it was being merged with the police, and so at the request or with the approval of my Cabinet colleagues, I, as a member of Cabinet, went to see a number of Queen's Counsel, mainly in Auckland, about whether these powers were needed for the Serious Fraud Office. The advice that I received was that we were naive if we thought that some of these powers weren't necessary for the Serious Fraud Office, and therefore the advice was that these powers should carry forward for the Serious Fraud Office in some form. There was also universal, but for one person, universal view that the Serious Fraud Office abused their powers because they use this non-warranted route for normal investigations that should be carried out either through normal investigatory processes or through the police in ways that get warrants. And so there was a view of the Law Commission, as well as the senior lawyers involved, as well as the Labour Party Cabinet, that we needed to carry forward these powers of the Serious Fraud Office to this new joined agency for both the police on serious crime and the Serious Fraud Office in respect to their serious fraud problems. We reached that view because we realised that some of the most pernicious crime by organised crime and gangs is even more serious, or at least as serious as the crime that's dealt with by the Serious Fraud Office. And if those powers were justified for the Serious Fraud Office, we couldn't see how we could say they weren't justified for the police. So hence we had the situation where the government, now the national government was elected, they had campaigned against the Serious Fraud Office being merged into the police force, and we accept that as their right. But then we had the carry on of the new powers for the police, including this derogation or undermining of the right to silence through production orders and examination orders through the police. And we agreed at Select Committee that that needed to be surrounded through very careful protections of civil liberties, the most fundamental of which is that you have to get a warrant from a judge. Now, this problem remains in respect of the Serious Fraud Office because they don't need a warrant. It was outside the scope of the bill. We said we would cooperate with the government to bring forward another bill to make sure it happened. We said that we would cooperate through the Business Committee to make sure that parallel legislation could be introduced to this House. It's easy to do. We did it this very day in the House in respect of some of the Maori settlement legislation earlier today. So it can be done, Minister, and it can be done easily, as was done this very day in respect of settlement legislation. I wrote to the Minister of Justice in November 2010 in respect of these very issues, and I laid all of this out. I did not get a reply until after the election. At the time, because of delays, I speculated to both my colleagues and to the police that this was an act of political subterfuge, effectively, and that was the real intention of the government to reply so late in the piece that they could just push this legislation through after the election without addressing this very serious issue of media freedoms. Media freedoms are absolutely essential to clean democracies. If you do not have a free media, free of intrusion from state agencies, you cannot guarantee the long-term strength of your democracy. There are a number of things that are piling up in New Zealand that show that this government has a poor record in respect of media freedoms. I don't have time to go through with some of the attacks on civil liberties during the last 3 years, but I do have time to note to members opposite the abuse of the Prime Minister's position, calling in the police to hound media sources after the T-tapes went wrong. That was wrong. That was an attack on media freedoms. I do have time to recount the fact that under this government, the Serious Fraud Office, without a warrant, went into the National Business Review and put them at risk of prosecution and fines and criminal penalties because they would not hand over their records about the press's investigations into the South Canterbury finance. I do have time to report how terrible it is that we have the Prime Minister's electorate's chairperson from the Helensville electorate elected to New Zealand On Air and trying to interfere with the timing of programming up to the election when that Mr McElroy tried to stop the airing of a documentary on child poverty prior to the election. I do have time to talk about Minister Joyce doing a sweetheart deal with one of the commercial companies in respect of frequency fees for...
Point of order.
This is
Simon Power.
Well, almost, but not quite. Simon Bridges. Mr Speaker, this has absolutely nothing to do with the bill now. The Speaker has strayed very wide of the mark of this bill, and what he is saying is irrelevant.
Well, speaking to the point of order,
Mr Speaker, I am emphasising why media freedoms in respect of both the police and the Serious Fraud Office need to be dealt with in this bill. Mr Speaker, this is clearly within order, and I would request the right to continue.
Debatable issue. I call the Honourable David Parker.
Thank you, Mr Speaker. So, against that background,
Point of order.
This wasn't a debatable issue. I was asking you to rule on a question of relevancy.
Well, I have ruled on the question of relevancy. It is a debatable issue.
Speaker, so not having had a response from the Minister during the period prior to the election, what turns up the day following the election? The day following the election, I get a letter from the Minister, by then ex-Minister of Justice, Simon Power, effectively saying we're not going to do anything about it. They didn't even have the decency to point out the date of the letter that I'd sent them because they were so embarrassed that letter was over a year prior. So, Mr. Speaker, this is very, very important legislation. We should have agreement across the House in respect of search and surveillance legislation. It ought not to be an issue of political controversy. And yet we have the government refusing to move on the issue as to whether the Serious Fraud Office needs these powers. They say now in this latest letter they'll look at how often they're abusing them or using these powers. I say that I don't need to know anymore. I know that the Serious Fraud Office marched into the National Business Review and without a warrant from a judge said, give us your records. That is wrong. That can be fixed by this Parliament, and unless this is fixed by this Parliament or we get an agreement from Judith Collins that she will fix it, we will accept an undertaking that they'll fix it in the next little while. Well, unless they do, you've got to scrap on your hands with this. Order. Because it is wrong, Mr. Speaker. It is wrong, and the problems in respect of media freedoms need to be addressed.
I call the Honourable Member David Clinton. Tēnā koe.
Mr. Speaker, I'm pleased to take